So you ready? Everybody seems so quiet. Thank you. All right, so we've got a couple of different ways of approaching the afternoon. So particularly, depending on which way we go, if you're online, I'm going to remind you about the desk lectures that I've already done, which I'm hoping a number of people in the room have had a look at. And instead of just going through and me talking at the law at you, I think I'd like to go straight into an activity if we can. But again, just want to gauge where we're up to. So we're at topic 5? 4? No, I think it's 4. Yeah, and I've got 5 on the slide. This happened to me before. Sorry, must actually fix that. I wish I could actually edit slides on the run, but I can't. So we're going to, before we do anything, I am going to tell you about this thing next Monday on the 16th at, it says 5 there, but it's actually 5:30. Everything's wrong. Doesn't have the room in it either. I will send you an email with the actual details, including the online details, so I'm going to live stream it. But Pauline King from the library, who many of you will have met, she's our liaison librarian, and a mate of mine, the wonderful Sue Ann Yap, who works for a company called Jade, are going to come in next Monday to do what Sue and I are calling how to be a ninja researcher. I've run this or something similar to it either in the class or separately. We don't have enough time in class, so I've run it as a separate class for the last couple of semesters, purposefully immediately after you've got feedback on your first assignment, and ideally when you've got your second. But it's not just for contract law, it's for anybody. The LSS are hosting it, and they've done all the work in getting it organised and put together. I'm giving my time out of the goodness of my heart, just because I don't like reading things that haven't been well researched. Only go for about an hour. You can participate online using basically the same sort of technology that we use for the drop-in shoots. Plus I'll have some helpers, which means that the chat function can be monitored a little bit more. Last time we did it, we had more people drop in online than came in face-to-face. But if you can come in face-to-face, it's more fun, and with any luck there'll be some chips and, I don't know, I'd love to say beer, but I doubt it. There might be water and chip. No, it's in a room in this building though. 408, thank you, 408. So it's been advertised by the LSS. All of the details are on the LSS's Facebook page, I believe. And yeah, we picked Monday nights. I don't know whether it overlaps with classes that you might have or not, but Monday is the night on which the least number of classes are held. So that's why we picked that night. Well, actually, that's not true. Friday would be the night with the least number of classes and the least level of interest in coming here. So, so basically, come with questions. We'll have a kind of focused problem to have a look at, but essentially what we really want to do is look at where do you start, how do you think about starting, what tools do what things. A lot of the early research stuff that you get is, if it's sort of framed around the idea, if you're looking for this case, how do you find it? Well, when you're solving a problem, you don't necessarily know what case you're looking for, right? So it'll be a bit more focused on case law, finding case law or legislation than anything else, but we'll have a little look at some of the tools that are available and hopefully have a bit of a laugh along the way. Oh goodness, somebody's played with my slides and done the transitions. Awesome. My kids do this occasionally when I'm not in the room. They go and change things. So, okay, so what we're going to talk about now is intention. Next week we're going to cover 2 topics, so we're starting to speed up, And as you could probably guess by my plan is really only to have around half a class or an hour and a half on intention anyway, because we talk in this class about the feedback. So I want to start by looking at it in a big picture overview, and then really it's up to you. I've got a bit of a quiz game that, and I have prizes, actual trophies. Like there is an award. And I think that actually being able to apply these things, you're now at the stage where you can do that. You've got enough to do that. So that's what I'd like to do. What I'd like you to understand, though, is some of the historical basis for intention. Any of you had a look at the video that Dave Goodwin has put in for intention at the beginning? A couple of you. I don't love that video. I love Dave, by the way. If you're listening, Dave, I love you. I don't think that video really nails it. I actually think intention is a hell of a lot simpler than that little video really points it out. See what my next slide is, and that might be able to help. Yeah. So basically, intention is just, we need to see a manifest intention that the parties will enter into a legal relationship. It is not a high bar. Back in the olden days, and a lot of the cases that you will have looked at are really old, right? That basically the law looked at it pretty simply. If we're talking about a commercial contract, then there was a presumption that the parties intended that it was a legal relationship. And you would need to see, it almost became a negative, you would need to see something pretty clear that the parties didn't intend for there to be a contract, that their intention was that something was just being done as a favour, or that it wasn't intended to be binding, that it was a gift or something like that. And the opposite presumption applied in relation to domestic and family relationships. So if we're family members, particularly if we're talking husband and wife, there was a presumption that a family relationship isn't a legal relationship and the parties didn't intend for it to be a legal relationship. And you would need to see something very clear to indicate that there was a manifest intention for it to be a legal relationship. So it wasn't impossible. Pretty much since the case of Ermogenes, which is a key case here, and we'll talk about the detail of that if you need me to, under Australian law, that really doesn't mean anything. Those presumptions are, at best, a way of identifying who has the onus of proof to demonstrate that a contract wasn't intended. So if there's a contract or a purported agreement between family members or friends or people who have met in some sort of social context, and one party is claiming that there's a contract, the onus is on the party who is claiming that there is a contract to demonstrate that there is a contract. But it's not a high bar, it's just they're the ones who have to do it. Similarly, if we've got a contract or an agreement between two commercial people and a party is seeking to say that there was no intention for that to be a binding relationship and that's why there's no contract, then the onus is on the party who is who is making the claim that there is no contract to bring that evidence. Again, it's not a high bar. It's quite difficult these days to be able to get out of a contract based on intention. Now, there's one relatively recent case. Let's see who's done the reading. Case involving Richard Pratt over recent years, where that has been a case where a contract was claimed based out of a social or a domestic relationship. So essentially, Mr. Pratt had a friend, her name was Madison Ashley, is that right? Ashley Madison, No, that was a completely different thing. Anyway, Ashton, Madison Ashton. Ms. Ashton was formerly a sex worker. In fact, I think at the time, I don't remember the facts ideally, at the time that she entered into a conversation with Mr. Pratt, who was a very wealthy married man. I think she was continuing as a sex worker, or she might have been thinking about going back into that work. She also had a side business selling jewellery. He said to her something along the lines of, I don't want you to do that. I will look after you financially. I will educate your children. I will put some money aside for them. And in exchange for that, our agreement will be that you will not return to sex work and that you will be my mistress. Subsequently, Mr. Pratt died. The evidence is quite, and the slides have got some detail around the evidence, but there was a number of conversations that were recorded, that solicitors were involved at some point. There was lots of going backwards and forwards, but in the long run, the estate, Mr. Pratt's estate, claimed that there was no contract, that there was no intention for the parties to be bound, that this was not the subject matter of a contract. And ultimately the courts agreed with them. And the courts agreed with them for a number of reasons that really related to the subject matter of the contract. And it really came down to the judge saying something along the lines of, in fact, why don't I make this more helpful by pushing through to the actual slides? So this will drive those of you who like to follow slides insane. So here's the slide with her picture on it, which is how I remember where they are. But I'll see if I can get the text is on the slide. It's really annoying that. I'm so sorry. So, again, Irma Genus is our key case here. We can talk about it in some detail, but I just want to really talk about the Pratt case, and then I want to talk about the honour clause cases, and then we're going to do an activity, because I just want to make sure we're all on the same page with this stuff, and then we can work from there. So in dismissing this claim that there was a binding contract, Irma Genus is reaffirmed. Now you'll find, if you go and do the research here, you will find that it's reaffirmed regularly. There was quite a good case, a family law case at the end of last year, Beadle and somebody or other, which it's largely a family law case. It goes on and on about who gets to have access to the children, and whether it was involved with farming property and who owns the stock and all the rest of it. But bizarrely, I can't remember the name of the case, but I can remember from paragraph 160 onwards for about the next 5 or 6 paragraphs. It's a really good, concise summary of the law in relation to intention. And if somebody reminds me to do it, I will send you the link to it. And it might be on this slide pack as well. I just can't remember. But this Irma Genus is not in dispute. It is applied. So the fact that a contract constitutes a family arrangement doesn't raise any particular presumption regarding the party's intention to enter into that contract. And I think the way that David expresses that idea in the video is a little bit misleading. I think he's sort of oversimplified it and as a consequence made it more complex. So just wanted to point it out to you. But then the court found here that the parties didn't intend to create legal relations, and even if they did, the contract would be void for uncertainty. So in particular, and quite frankly, I have some issue with this case. I think that the judge is applying a particular moral code, which may or may not be a moral code that you agree with, but I think it's an interesting way to look at it, shall we say, and I'm not sure that this is a case that will stand up over the longer term. Regard was had to the nature of the arrangement and the lack of any language of obligation and the failure to delineate important terms. In particular, what Ms. Ashton would need to do as Mr. Pratt's mistress. Really? Really? Exactly. We can go with some implied terms later on. But it was also inherently improbable that Mr. Pratt would have bound himself to make significant payments in return for a promise that was essentially unenforceable. So, and I guess there is an argument perhaps that a contract for the purchase of sexual services, if that is what we're reducing mistress to, but again, you know, look, I don't want to impose my moral thoughts about this in any way. I just want us to analyse this and think about it like lawyers. I think the idea of mistress is something different, and I think the parties probably did know what their intentions were, whether the consideration wasn't necessarily a promise to have sex with him. It was quite more likely a promise not to have sex with other people. Like, it's not very hard to sort of work this through. But at the end of the day, this is a good example of a case where these issues have been thought through. But it takes this kind of, and there was a huge amount of money at stake. And I mean, you know, I got to say, I feel very sorry for Mrs. Pratt. Mrs. Pratt has, you know, Richard Pratt's widow has, this is not the only one of these cases that she's been in court with, and she's fought every single one of them. It's, you know, like, it's a cluster muck-up of epic proportions when it comes to family life. But as a contract example, it's a very interesting one. Okay, I'm going to go back now to where I started. So the other side of this intention is just the question of, well, what happens in a particular category of agreements where commercial people don't want their arrangement or their agreement to be a legally enforceable agreement, that their intention is to take the arrangement outside of the law. And the issue arises in two particular categories of agreement that we're going to look at. One is the preliminary agreement. So preliminary agreements, the key case here is Masters and Cameron. But preliminary agreements are really important in a commercial context. Most of the examples that we deal with in the classroom are necessarily quite simple, in the sense of, even the one that we've just been through in class today, the assignment that you went through, we've really only got 3 actors in the, or people, well, I guess we've got the friend later on who buys, but there are only 3 people involved in the key conversations or communications: a purchaser and 2 representatives of a vendor. And we've only got one. The subject matter of the contract is also pretty simple. There's a thing, it belongs to one person now or one company now, and it will be transferred to another company at a later time, or another individual, if there is a contract. Mostly those are the sorts of things that happen without any lawyers involved ever, right? They're very straightforward contracts. But if you are involved in any kind of complex transaction, then often you have all sorts of different stages in that negotiation. So my particular background is in the M&A space, mergers and acquisitions space. So most mergers and acquisitions transactions start with a whole raft of preliminary agreements. So they will start with one party usually getting somebody else. They usually don't do it themselves. So one company will get an investment banker or some sort of agent to go and knock on the door of a company that they either think they might want to make an investment in, they might want to buy, or that they think might be interested in buying some asset that they have to sell or something like that, or even buying themselves. Sometimes they'll go to 3 or 4 different parties at the same time. And usually, particularly large companies, they don't want people knowing their business. They don't want anybody to know that an asset's for sale, or they don't want anybody to know that they're interested in acquiring something else, because that just might make other people interested. But they do need to do what's usually referred to as due diligence. They need to look at what it is that they might be buying, or what warranties they would need to give if they're selling. So it's not as simple as just walking into the shop and saying, I'd like to buy that, here we go, hand over $20 billion. Yes, that'll be in US currency, thank you very much. It just doesn't work that way. So usually you have a raft of preliminary agreements. Some of those preliminary agreements, in fact, you might want to have as binding arrangements. So the example I just gave is most people don't want other companies knowing their business. So often you'll start your negotiations under a confidentiality agreement, and you'll want that agreement to be binding. Sometimes you want to negotiate with a party on an exclusive basis. If I want to buy something that you've got to sell, I don't want you shopping it around to other people at the same time. I want to be the only one at the negotiation table. And so I want an exclusivity arrangement to be binding. But often I don't want my first draft contract to be binding. In fact, I don't want it to be an offer. I want it to be something that we sit around the table and that we deal with. Sorry about that. Oh, what have I done? There we go. So the preliminary agreements and early drafts, working out what stage of the negotiation they are and whether they're binding or not, can be a really important thing, particularly once we're getting to term sheets. So a term sheet is like a letter of offer, or a letter of intent is another language that is used, which really maps out either, and it'll depend in each case, the terms of the agreement that the parties have reached in principle but needs to be documented in some way, or the terms at which they might want to get around the table and start their negotiations. So each time we have to work out, is that document or is that agreement that's been reached, is it binding or not binding? So Masters and Cameron helps us with that. It identifies 3 categories, and subsequently the Baulkham Hills case suggests that there might be a 4th, under which we can classify what the standard of agreement is. So I'll go to that in just a second. The other kind is honour agreements or honour clauses. All right, I'm going to lose my voice, so I'm going to ask somebody. Anybody want to give me an overview of what an honour clause is? Or an example even of where it's used?
Essentially an honour clause that the distributor would be allowed to distribute the manufacturer's product, and the agreement was in honour only.
Yep.
There was no binding arrangement that this would continue for a specified period or for, indefinitely or anything like that.
Yeah, absolutely. So it's really sort of a statement of current intention with being very clear that it's not intended to be binding in the long term. Where they really matter is when they're used or particularly matter is when they're used in financing transactions. So with your indulgence, actually, they're the cases that I want to look at next before we play with this. Please interrupt with questions as you go, by the way, if you have them. So let me find where I'm at. Okay. So yeah, I just want to talk about some of these trickier circumstances, because if you don't have the commercial background, these might not immediately make sense to you. So, commercial transactions, as I've said before, they're presumed to be intended to be binding. So this is very rarely a contentious issue. Letters of comfort hold some particular problems, and the parties themselves can negate, in the example that you just gave us, their intention to be bound. So, that is going to do my head in, that way that's transitioning anyway. Okay, we will cover this a little bit more in certainty, but because it's not necessarily in the reading, I just do want to point this out to you. An agreement to agree can't be binding. It fails for lack of certainty. We'll agree something in the future. So a clause in an agreement or an arrangement between us that, you know, if we have a fight, a dispute, we'll keep it away from the courts, we'll just put our two CEOs in a room and they'll agree how to deal with it then. That itself can't be binding. The outcome, you can't agree to agree because you might never agree. It's completely lacking in certainty. You also can't exclude the jurisdiction of the courts. You can make it a requirement for the resolution of any dispute that the parties have a go at mediating it first or negotiating, and that is a necessary step before the court will hear your claim, but you can't agree to agree in the future.
Can I ask, then why does the lawyer actually representing those parties draft something like agree to it?
Why does the lawyer representing those parties or one of them draft something like that? A competent lawyer wouldn't.
Yeah, that's what
But it again, particularly in a preliminary agreement, often people don't use lawyers. People don't always use lawyers, sadly. So you very rarely see an unenforceable clause, but again, that's one of the reasons that we'll point it out to you. So I want to talk about these honour clauses. I don't want to talk about that one in particular. That's the Rose and Frank is the one that you were talking about, isn't it? So let me just go. I want to talk about Banque Brussels. So I want to talk about situations where lenders seek security from a parent company. So I think actually this will help us the most. So this is, so some of us are showing our age by remembering the name Spedley with a little bit of distaste. So Spedley Holdings was a ASX listed company. It had a subsidiary, a wholly owned subsidiary called Spedley Securities. And Spedley Securities borrowed $5 million. It seems like such a small amount now. It actually also shows how long ago this was. But it borrowed $5 million from Banque Brussels. ANI was the owner, ANI owned 45% of Spedley Holdings. So it was one of the I think it was the largest shareholder. Ultimately, if the name Christopher Skase is familiar to any of you, he was essentially the controller ultimately of this company. So basically, Banque Brussels said, before we lend any money to Spedley, to securities, we want you, ANI, so 45% shareholder in the holding company, to give us some sort of security that the money will be paid. And so basically what that looked like was it included these two terms. So there was a letter that Banque Brussels sent to, ANI sent to Banque Brussels that said, amongst other things, it's our practice to ensure that our affiliate, Spedley Securities, will at all times be in a position to meet its financial obligations as they fall due. They also said that if we decide to sell our shares in Spedley Holdings, so if Spedley Securities ceases to be an affiliate, we'll tell you 90 days before we do that. Anyway, they didn't. They decided to sell. In fact, if they had done that, the listing rules would have required them to tell the market that they were going to do that, which would have resulted in a massive crash anyway. But anyway, they basically disposed of their shares without giving that 90 days notice. Spedley didn't pay the $5 million back, and Banque Brussels sued ANI in contract. They said this letter of comfort was a promise that if your affiliate defaulted, you would make up the difference. That was effectively what it was. ANI said, no, that's no requisite intention. We didn't intend to be bound. We just gave this letter of comfort that made those promises. So what do we think? What happened?
The letter of comfort actually indicates that they were going to be bound.
Yeah, well done. The letter of comfort absolutely indicates that they were going to be bound. And it's got these two things in particular, because even if they weren't going to, whilst they're saying it's our practice, whilst our affiliate, whilst they're an affiliate, to meet that they'll meet their obligations. Coupled with that, we'll tell you 3 months before we stop being affiliated. That gives you time to call on the loan or to do something else, is effectively what that means. So you've worked that out from well, you might have read the case too. I'm just saying it's consistent with our with the principles we've dealt with so far. So, questions that the court considered were, was there intention, and were the terms in the letters sufficiently promissory in nature? So something we'll deal more with the idea of what the terms in the letter are when we look at the contents of a contract towards the end of the semester. Here the court held that the starting point is the prima facie presumption in commercial transactions there's an intention. And the onus of proving the absence of intention rests with the party who asserts no legal effect. So the party who's saying there's no intention, ANI in this instance, is the party who had to demonstrate that, and they were unsuccessful in doing so. If the statements are promissory in character, the court should enforce them when uttered in the course of business and when there is no clear indication that they're not intended to be legally enforceable. The letter given by ANI included enforceable contractual promises to provide the notice, and so the bank was ultimately entitled to damages. Feels pretty straightforward, right? The magic of contract law. The same year, this case was decided in the UK. So in this particular letter, I'll show you the flow in a minute, a letter of comfort was given that included a statement, it is our policy to ensure that the subsidiary is at all times in a position to meet its liabilities to you. So let's have a look at how this one works. So this is, many of you will know this company, MMC, Malaysian Metals Corporation. It had created a subsidiary for the purpose of investing in tin. And the subsidiary here was 100% owned in this case, so we've only got two companies in, so it's a little cleaner than the structure that ANI had. They've borrowed 10 million quid from Kleinwort Benson. And essentially that was a facility to trade on the tin exchange, on the London Metals Exchange. There were two letters of comfort that MMC gave to Kleinwort Benson about this transaction. And there was also a head agreement in relation to the loan. In relation to the financing that the whole of the group had through Kleinwort Benson. So the total borrowings were greater than this 10 million facility. But the 10 million facility was advanced to MMC. It's also relevant to these facts that at the time that these letters of comfort were given, they were given in replacement for what Kleinwort Benson had actually asked for was a guarantee. So they'd asked for an actual guarantee. And MMC said, no, actually that's not what we do. The reason, and you'll learn more about this when you do company law, but the reason that we've created a subsidiary is this is a high-risk trading operation. And we need to borrow money to do it. Other people will lend it to us. But if you want this, we want the best terms, but we're not prepared to guarantee it. It's up to you to work out what your risk is here. Okay, so and I think that's very relevant. So I've got in the corner of my eye, somebody possibly putting up their hand a second ago. No, I make things up. So, in this particular case, okay, sorry, they're the facts. Don't you love it when the facts are on the slide? In the first instance, it was held that commercial people intend their agreements to be binding, and the letter that contained a contractual undertaking was effectively underwriting the indebtedness. So same result effectively as A&I. But on appeal, it was held that the letter didn't contain any contractual undertaking. It was a representation of fact that only carried with it a moral obligation on the part of MMC. It's their policy. I think it's also relevant here that the letter was not the only part of the transaction. So the letter came out of a negotiation that requested a guarantee. But when we talk about the parole evidence rule, you will come to understand that often evidence that contradicts or is different to written evidence isn't admissible in discussing what the contents of a contract are. So, sorry, back. So we've got these two very different results. Is that disturbing?
Yes.
It's disturbing. Okay, you don't like it?
Yeah.
Everybody else on Keaton's side?
Yeah, I don't like it either.
You don't like it?
They have only 45% of the volume.
You don't like it? You're thinking A&I's got a hard time. What about you, Ryan?
Implies that there's some kind of a test, which is nice because if you talk about the ambiguities of words, you wouldn't want a hard, like it's always one thing or always another.
So, you've got a very small voice. Well, not a small voice, low voice, that's right. So I think that started with, that implies that there's some kind of test, which is actually giving you some comfort.
Yeah.
I'm with you, Ryan. I think actually these are different results, same application of the law. So essentially these two cases say to me, in order to work out whether or not there was an intention, we need to look objectively at what actually happened. And if we look back here at, oh, that's going to, I'll just go and do it the other way because that's just going to annoy me. If we look at this one, and we look at the wording that was used, we've got this additional piece in it, which is a promise that we will give you notice. So the wording is slightly different. Practice as opposed to policy. Practice is stronger than policy, but only just. I don't think a lot falls on that. But it's coupled with this additional promise. So that we have this practice of supporting these affiliated entities. And if it stops being an affiliate, or if it's going to stop being an affiliate, we'll give you enough notice so you can put other arrangements in place.
Well, it sounds like they consented to that particular instance. That's not just their practice.
Yeah.
They actually said, yes, we will do this in this case.
Yeah, exactly. So looking at all of the facts of this particular circumstance, we're looking objectively at what it is that they had promised and how they'd behaved.
Question, and it might be really dumb. If that wasn't in the letter of comfort, but say it was in their company policy, would that, like, it is our practice to ensure that all our affiliate companies will at all times, like, as a general policy statement, would that still be binding?
It's a really, I don't think it's a dumb question, by the way. I think it's a really interesting question. I want to throw it back to the room. What do you reckon? If somebody has got a policy, an internal policy,
Like if it's like it's kind of like a blanket intention as opposed to specific to that scenario.
see, I think just looking at the logic of where we've got to here, as to what intention needs to be manifest based on an objective test. So if we've got an internal policy, I don't know. So Ryan, you wanted to, I'm going to come up.
Yeah. In terms of just being like, oh, it's our policy, like just the vagueness, it sounds like this is an intentional practice to be vague in order to seem to be promising something but not really promising something. There was an interesting thing in the textbook that I'm not sure whether it's part of the actual what was held or whether it was an observation by the judge. Something about under French law, that there was it's just like, no, you meant it because it was unacceptable that in commercial law there would be you could create something that meant nothing. There was something else in earlier.
Because they're doing that.
A judge pointed out, it's like you can't. There's not going to be a clause that means nothing, so we're going to construe it to mean something.
Yeah.
If it means something, it means this, because the alternative is it means.
It doesn't
this or
make any
nothing.
sense. Absolutely. So looking at just pulling that back to your question, I think if it's an entirely internal policy, then external people don't know about it. All they might be able to do, just say this is a particularly forthright company, they might, in their own internal analysis of whether this is a good risk or not, say, well, they've always stepped in when other subsidiaries have going to default before. Small disclaimer in a very fast voice, past performance is not always a good indicator of future returns. And they might have taken the risk on that basis. However, if in their pitch to get this loan, they've gone out and they've told the world, told it, this is our policy, we've always done this before, we're always going to do it again, then again, they might have something to deal with. When it's actually in the document, again, there's a Latin word for that drafting rule, which is just going to avoid my tongue for a minute. But essentially, a court will look at a document or look at anything that's before it when it's encapsulated in a document and say, parties don't waste their time just putting in things for no reason. So if they put something into a document, then they've put it there for a reason. So basically what happened in this particular case with Kleinwort Benson, just to go through to the other one, the onus is effectively, now Kleinwort Benson is a UK case, but I think it would have fallen out the same way in Australia because essentially here the onus was on MMC to demonstrate that there was no contract. So, and that's how it would fall out under homogeneous. So, and in order to do that, they pointed specifically to evidence that included, we refused to give a guarantee. We told them it was our policy, but we wouldn't do anything more than that. So again, completely different results, but completely consistent application of the law because we're distinguishing on the facts. And that's a really important thing to identify, particularly when you're doing assignments. Is that you can have really similar facts, but if they're not the same, you've got to look for those distinctions.
But I thought I read that internationally everybody is viewing this as a contract or agreement to a guarantee in a certain way that is not on their financial books. So regardless of what is the wording, I think in this case it was because of the way they use the word policy or whatever, that actually doesn't shows that it is mainly doing it for guaranteeing the loan for the other party, but all the international corporation right now is viewing the letter of comfort is actually one of the instruments.
Well, you're an accountant, aren't you?
Yes.
Okay, so this happens from time to time. So, by the way, accountants are far superior when it comes to dealing with this than lawyers are. Because accountants at the end of the day need to allocate on a balance sheet and make provisions for short and long-term liabilities. And so they will look at all of the documents and actually it doesn't particularly matter to them whether or not it's a contract or not. The accounting standards will tell them whether they need to make a provision or not. And whether or not they've made a provision may or may not influence a court in a subsequent decision about the issue, but they're actually separate things. So the accounting standards are not the same as the law. They should mirror each other to an extent, but they're not the same because a provision is just making a provision in the accounts. If there's a fight, you will make provisions for fights that you hope to win and expect to win.
But I I thought that the letter of comfort is to create invisible liability that is not on the books at all.
So a letter of a comfort, well, it depends on what the accounting standards say.
Because if it's a liability in some sort, it would have been a document to support that, to do the journals and whatever. But in this case, it's just a letter.
But under the accounting standards, you may still have to make those provisions. I mean, that was the downfall of Centro in the long run, was that they treated a number of facility arrangements in one way because they'd always been able to refinance them in the past, but the accounting standards ultimately said no, they should be treated as short-term liabilities, not as long-term liabilities. And then, as it turned out, the bottom fell out of the market and they couldn't refinance them. So the accounting standards don't always match up, and you don't necessarily have to have a legally binding agreement in order to be required to make a provision under the accounts. But I don't want us to get too caught up in that because it's not going to be particularly relevant to everybody else. But again, often my starting point when I'm trying to deal with these kind of issues will be to talk to the accountants, the auditors. How have you treated this? Because that also gives me some indication of what the intention of the parties might have been. Okay, the last one I want to have a quick look at is... No, I think I'd like to go to our little quiz